Hello viewers, welcome to our program on immigration and legal affairs. I am your immigration attorney Michael Fulwani, and once again we have with us attorney David Nachman. David, welcome.
Thank you so much, Michael.
Now in our today's program, let me start with telling you what happens many times when people go and apply for a visa, immigrant visa or a temporary visa at the American consulates abroad. At the time of interview, the consul may decide to issue the visa, and then you will tell them your visa will be granted, you come and pick up in the evening. But there are many times when the visas are denied. On the temporary visas like a student visa or a visitor visa, sometimes they deny under section 214B, which means the consul doesn't think that this person is going to go back to India after visiting. He may stay back and therefore he denies under that category. Sometimes the person might have committed fraud or misrepresentation, and that goes with the temporary as well as the permanent visas. Consul after the interview will find, if he finds, he will say your immigrant visa application is denied because of fraud, section 212A6C. In some cases they may say section 212A6E, which is a smuggling charge. But many of these reasons, most of the time in those kind of denials, it is pretty much clear to the applicant why the consul is denying. There's something else where there are a lot of mixed things into that category, section 221G, which is a section under which there are different situations based upon which the visa is denied. Let's get an example of an immigrant visa person, whether it's a family-based petition, consul interviews, or employment-based petition, consul interviews, and he finds that there is some documentation lacking. Maybe an affidavit of support, maybe the birth certificate, maybe the police certificate, whatever. In those situations, he will say 221 denied, but you can bring the following documents any day between such and such time. And that's where I would always say that this is a denial. A lot of times people who were denied under 221G, because the consul is saying you can bring them back, they don't think it's a denial, it's only asking to bring papers. But the Department of State has very clearly advised, when you are filling up any forms or anything in connection with a question, have you ever been denied a visa? And if there's a 221G denial, say yes, don't say no. Because this is the recent thing, the Department of State said that's the way you should treat 221G denials. Okay, so as I said earlier, it is very simple. On those denials, he needs a passport to be renewed, he needs a birth certificate, marriage certificate, whatever is missing, bring back easy. I mean, in most cases, the 221 denials can be overcome by giving them the information and the documents that the consul is asking for. Now, but there are situations the consul says nothing. Your visa is denied, administrative processing. Now, that's a very cleverly words used by the consul. He says, I don't want to tell you the exact reason. Why doesn't he want to tell the exact reason? Because in some situations, the consul wants to investigate. Investigate, it may be a fraud, it may be something to do with documentation, like a marriage certificate which doesn't appear to be valid, like a divorce which is really actually not a real divorce but a paper divorce only. This happens based upon the interview. The consul asks a lot of questions. Interview and previous applications the people have made in that consulate, they have, and the records also. Now, unlike the old times, the American consul has access, wide access to many sources. They can go to the Department of State, they can go to the motor vehicle department, they can go even to the IRS. So they are getting, a lot of people say, oh, but how did he know? How does he know? He knows, believe me, better. So when you are going and applying for a visa, most important thing, tell the truth. Because you lie, they are going to catch you very easily. So in those situations, people say field investigation. What's a field investigation? Because there is an investigation they can do by calling the employer or by calling a university, verifying the education, or going in the field investigation is when somebody physically has to go, even a village, even a town, go there and go and knock the door, and the person comes out and they say, where is Mr. Such and all the questions they have. Person said that he was unmarried, he was getting a visa as an unmarried category, and the people there say, oh, he is married. The wife comes out of the person, and they say, who are you? Say, I am wife of such and such. Oh, then they know it's married, and consul already had a doubt actually. Most of the cases they have some kind of doubt, as a result of which they conduct field investigation, and those cases get delayed for a long time. I mean, I've seen in some investigation cases, the consular staff will say, this is an insurance company about insurance, and we want to find out where is your husband working and all that, and they get all that information. So you have to be very careful. Also, in some cases, they need some information from USCIS in the US. Situations where a person might have been deported, excluded, arrested, or something. So this is sometimes they need investigation. They won't tell you. They don't want to tell you. Even lawyers, when they go to the consul, say, "But what is it? What is it?" They say, "No, we'll let you know. Don't go home. Don't call us. We'll call you when you are ready." In some cases, there's a security clearance issue also, and they don't want to tell you that. But between like David and me, we will say that we know many of the situations when the client comes to us and we say, what happened in the interview, what you said, what the consul asked. We are trying to figure out, in most instances, based upon the fact we figure out what may be the reason. David, you want to make some comments on this?
I think one of the things that, as a practice pointer, Michael, you would agree with is oftentimes people get turned away from the consulate, and sometimes they don't even know the reason for the denial.
Yeah.
And what do you do in a case like that? What we generally try to do is we tell our clients to go back to the consulate and get something in writing. Make sure that when they give you an answer, make sure you have something in writing.
But David, administrative processing cases where they are going to conduct the investigation or there is a security clearance, counsel will not say, it will simply say administrative processing. Now, I had this discussion with other consuls, and many times I went and told them the State Department has clearly said, if you're denied, you have to be little specific and tell. But again, on the side of exception to that is the investigations and the security clearances. I think we have to take a short break, and right after the break, we're both going to discuss more about the 221 denials and how people can overcome that. So stay tuned. We'll be back.
We'll be right back.
Welcome back. Just before the break, we were discussing about Section 221G denials by the American consul when people go and apply for the visa. If they don't get the visa, it's denied, they will do a denial under 221G. And I was talking about mostly in the general cases, the family-related cases. Let me ask David, what about the clients that are applying for an L visa, H visa, or an immigrant visa based upon labor certification, PERM? They also deny in some cases under 221G. Now 221G, as I said, is not a permanent denial. It is a denial based upon the fact that the consul needs either more document information or investigation. So what is your thoughts on the consul denying for 221G on an H or a L or a O or a P or an immigrant visa?
Right, well, as everyone knows, probably, you're not likely to get a 214B denial on a non-immigrant visa because, of course, you have a dual intent associated with those visas, so you don't have to worry about that.
You mean H and L and immigrant visas, there's no question of.
Exactly. So what you're going to see most likely is a 221G denial, and then what we usually do is probably the same as you do in your office, Michael, is we sit down with our clients and we do a formal debriefing. We ask them exactly what they encountered at the consulate. We ask them what the officer asked them and what the focus of the discussion was on. And then what we try to do is we try to ascertain based upon that where the officer was going, what the officer might feel the Achilles heel is. And then what we'll do is we'll try to bulk up the case by providing additional documentation if that's the appropriate manner in which to deal with it. Sometimes what we'll do is we will try to reach out for the consulate through various channels that we have available to us. If that doesn't work, of course, Michael and I as lawyers have access to a special database where we can contact the U.S. Department of State, speak to them in Washington, D.C., and in a way go over the heads, if you will, of the folks out in the field and try to get some kind of resolution through a special process that's available to lawyers.
I'm glad you said that because we have seen in some cases, we know that there's a legal issue for which the American consul want a legal advisory opinion from the Department of State. But before they say, I say that we should also do that always. When the consul indicates that he is referring the matter to the State Department for a legal opinion, we don't want to wait for that. I would immediately go in to prepare my own request to the Department of State, the legal net as we call it, and put in all the facts and my positions. That's the lawyering. I mean, the lawyer just sits quiet, okay, let the consul find out and let him make the decision. Now, obviously, the American consul is going to put his own position and try to convince the Department of State. But I want to tell the Department of State that you are looking at the presentation of the consul, you also look at our client's presentation. Then you like a law, like a judge. Judge has to listen to both parties before they make a decision intelligently.
Right, and I think, Michael, what you're saying is that when a 221 issue is raised at the consulate, then the consulate is arguing that there's a fact in dispute.
Yeah, but
However,
at one point, that is resolved one way or the other. They do the investigation, they'll come back and they say you committed fraud, we committed fraud. Then they have decided after their investigation. Security clearance cases generally get cleared in course of time. There's a real terrorism or crime, then it also comes up. Then of course, then we have to see what are the relief available and what we can or we cannot do. Now let me go further. Let's say that everything done, the guy is happy, the American puts a seal on the passport, visa issue. Now a lot of people say, okay, I got the visa, I'm going to get in the flight and go to Kennedy Airport and that's it. Not that's it. A two-pronged situation here. You may be convinced the consul and got the visa. Remember, when you are landing at the airport here, you got a CBP, Customs Border Patrol people. They are at the airport, they will talk to you, they will see your papers, they can stop you, they can search you, they can put you in secondary inspection. In the window, they are not satisfied. You go to the supervisor. And there's another rule. Yeah. Another role that they have to play, and people have to understand that technically when they reach the airport, they are making another application for entry, like open the door. And the door is still closed until the officer gets satisfied and let you stamp in and come in.
It's a form of checks and balances
Exactly.
that goes on, Michael. It's a situation where even though the U.S. Department of State has blessed the application, the U.S. Department of Homeland Security, which is a sister agency, has
There
to
are two
put their...
different agencies.
Correct.
Department of State and Homeland Security. Department of Justice in a way.
Right.
So what happens basically, you have to understand that at the port of entry, the officer wants to interview and make a decision. Now, what are the decisions they are making? In some cases, the officer clearly sees there's a fraudulent visa, this person is really not coming for a visit, or a student, or the H1 is not really bona fide. Whatever reason is, they can ask the person, what do you want to do? And you want to withdraw your application? Means, I'm requesting, okay, I'll go back, please don't deport me. Or exclude me actually.
And often asking for a withdrawal of the application is good because it is no prejudice to
And
the
it's
individual.
not a written application, anything.
Right.
You just say yes, what that means, do you want to go back on your own, or you insist, then we may have to detain you and you may have to appear before a judge. Some people say, okay, I don't care, appear before a judge, my visa is correct. But in most instances, it's a good idea that if there is some problem, it's withdrawn, at least you are not excluded for 5 years. So, and also as I said earlier, that they actually look at your baggage. Some people are, bringing things, and from that also I remember in one case a person in winter time, summertime, heavy winter coats is coming for 1 month in July, like this kind of weather today. Right. Why is he bringing the heavy clothes and woolen clothes? Somebody has got a medicine for 1 year in that. He's coming for 1 week and why is he carrying the 1 year?
That could be a manifestation of his intent to stay longer.
And right? He's bringing a letter that a friend wrote to him. All you have to do, just come on a visitor visa. We'll go to David Nachman and he'll get your green card. And he's carrying his letter in his hand. And they find a letter on him. You know what going to happen.
Of course.
Obviously, you have to be very careful. Somebody's coming on a visit bringing all his degrees, diplomas, resumes. So apparently he has got some intention other than merely visiting.
It's a very good point that you raised, Michael, also because at the port of entry now, we're hearing stories where the officers are confiscating computers from our clients and going through the computers. It's probably not a bad idea to make sure that your computers don't have any information on them which could be manifestations of intent that you don't want to be seen.
And sometimes even the green card holders, they went for a trip for a few weeks or months or a longer time, they are coming back. At the port of entry, the officer would ask, how long were you out? 8 months, 9 months, what were you doing, what do you do here? Right. In some cases, they simple put a warning on the passport, that 11 months out, it's like a signal to you. In some cases, they give a deferred, they let them come in, but then you come to the immigration office, the deferred inspection. And in some cases, they may take away your green card, but David, we are running out of time for this segment, and we're going to take a short break. After a short break, very interesting, you will see a new guest we have, and many of you have been wanting to hear about that. So let that guest come in after the break, and then we'll introduce that person.
Malka, who is a Canadian immigration lawyer.
So you know now that our next guest is a Canadian immigration lawyer. Stay tuned, and we'll be back with the latest information on Canadian immigration laws.
Off guard.
On TV Asia.
Welcome back. We now have with us our Canadian immigration lawyer, Veronica Malka, as we say in Hindi, Urdu. Welcome back.
Nice to be here, Michael.
Now, today's program, we was want to mention to our viewers that we got lot of calls, TV Asia we got, they want to listen something about Canadian immigration laws. Because many people get frustrated, they cannot settle in the US, some people have problems staying illegally here many years, some people have even deportation orders, and Veronica is going to tell you all about the temporary and permanent visas for Canada and how easy or difficult is it. So with that, let us ask you this question about how does the Canadian immigration system work? Like in the United States, we have labor certification for immigrant visa, getting a green card, you got to go through the process of proving shortage of US workers and all that. For relatives, we have different categories, parents and brothers and sisters and husbands and wife, different criteria, I believe. Can you please explain to our viewers?
Sure. The Canadian immigration system is somewhat similar in some ways to the American system, and in some ways it's different. We also have programs based on the economic side of bringing people into Canada, based on their profession, their job experience, and also a program based on what kinds of job offers they may have. Something similar to labor certification, called a confirmation process that requires a little bit of advertising. And then we have some family sponsorship abilities as well to bring in relatives from abroad.
Time periods, a big question our clients have. David will also comment on that. And US, you apply for a labor certification, green card, it may take 7 years, 8 years. And even the family category, sometimes even the husband and wife of a green card holder is taking 4 or 5 years. Married sons and daughters of US citizens may be taking 10 years, long waiting periods. What's the story in Canada?
No, the good news is in Canada it is not as long.
Really?
Yes.
Okay, so let's know.
How long? So depending on the job, advertising is only for 14 days. For example, an employer has to post a job on a national site for about 14 days. Sometimes another means of advertising is required. But if that job is a job where no Canadians can fill the job, and as we know, Canada has a booming economy right now, there's a big need for labor, and let's say that job is confirmed through the confirmation process, the applicant is really looking at something in the range of 3 to 6 months to obtain a temporary visa to come to Canada, called a work permit.
That's very good. David, you got a question?
Well, I was going to say that I think that there's something special about Veronique's practice, because Veronique is a Canadian lawyer, but she practices here in the United States, which gives her easy accessibility to people who are in the United States who may need Canadian law as a potential immigration option for themselves.
Very good point, David, because I know a lot of our clients who get frustrated, who are thinking of hiring a lawyer in Canada, try to find a lawyer in Toronto, Montreal, in Canada. And it is so difficult, everything is done on a telephone or by emails and correspondence. Here, you have the best advantage you have is here in the United States, the office in New Jersey. So It's always is a whole different picture when you are sitting with the lawyer, talking to the lawyer, asking all the questions, and any problems you are in contact with the physically, I mean, going and meeting personally. That's a very, very big plus, I would say. Let me ask you a question, which is a very common question people ask. People that have an order of deportation, and most people think, oh, I have a deportation order, so how can I get a visa for Canada, an immigrant visa for Canada? Is that a big problem? If a person has a previous deportation?
It depends on the reason for the deportation, but they will be asked to disclose whether.
I'll give you a very common reason. Is the person came in, applied for a political asylum. Political asylum was denied, and then they ended with a deportation in the US. No, that's not because the person applied for a political asylum, he thought he'd get it, he didn't get it.
They should apply to Canada. They should
No
apply
problem.
to Canada. As
Previous
long as they
deportation,
haven't
no
had
problem.
issues with Canada, and as long as they're applying for, I would say in such a case that they might want to apply for permanent residence as opposed to looking for a temporary stay in Canada. Often people say to me, can I go get a job in Canada or study? If they've been an overstay in the US, I will counsel them instead to pursue a permanent green card or Canadian green card permanent residency option, because the Canadian government might say, well, you overstayed your visa in the US, so who tells me you're not going to overstay in Canada? So if you apply for permanent residence, they're not going to say that
question
argument.
won't be there.
Correct.
Okay, so person says, okay, I want to apply for a permanent resident in Canada because I have a deportation order, and Malikaji said, no problem, but then he still has to qualify, right?
That's
You cannot just take a phone and call Malikaji, please get me the permanent resident status, I'll pay you so much fees.
That's right. A person
So
with
what are the qualifications, on what basis can you get him a green card, or a permanent resident, sorry, in Canada?
I often tell people that the way that the law is currently in Canada, and many of my clients are well researched and well versed already on that. They know that there have been recent changes. The best way to come to Canada is with a job offer. I have about a client a week that is able to find a job right now, job offer in Canada. It is easier than we think because the economy is good. And especially if we look at outlying areas, not just Toronto, not just Vancouver, not just Montreal. Take a look at the rest of Canada. There are beautiful provinces, Nova Scotia, there are Alberta, that offer a beautiful lifestyle, free healthcare, free education, wonderful, warm people that don't have as much labor. Therefore, your chances of getting a job are much greater.
Very nice. I think you are Minister of Tourism when you listen to the program. You're very happy that you're promoting people to come and
No,
visit.
because I left.
Very nice, very nice. Okay, so that's good. Now, people that we have, the type David will also agree on that there are some clients who already finished 6 years or 7 years of H1 and don't want to go back to India. There are other, until they can get a green card, they're waiting in a big line and they cannot stay legally. They want to be legal or not be subject to the 10-year bar because of unlawful presence. And they say, I want to go maybe H1 type of visa in Canada, I can 2, 3, 4 years, whatever time it takes for me to get my green card. What is the situation on that, like a temporary work visa?
I would say to those people, the first thing I would say is, where do you work? Is there an affiliate, a subsidiary, or a parent of your company up north of the border? Sometimes my clients come back and say, yes, I found out that we have one. See if your company will shift you up.
It's like our L1 visa
Correct.
in the US. Okay.
We have something like that, a visa transfer visa.
But that's not the case. Let us say he has an employer, technology, like person is the technology, computer science. He's working on H1, 6 years are up. Unfortunately, he did not apply for a labor certification, so he's not able to get any extension. But his immigrant case is going on. It's going to take another 2, 3 years, and he wants to go to Canada. And how much time would it take?
Well, right now, foreign skilled worker cases, this sounds like a foreign skilled worker case to me because when we're dealing with an applicant who has a substantial amount of work experience and education, it's a good idea to look to see whether they can have a sufficient number of points to immigrate to Canada. In addition to the federal system, which requires 67 points, most of which are given based on education, work experience, age, adaptability. If you have, let's say, a relative in Canada, that gives you extra points. Provinces also have point systems that are independent.
we are running out of time today, but you promise you will come on our next program and we'll continue this discussion and give our viewers most important recent information on Canadian immigration laws, temporary and permanent. Thank you very much for watching the program. Please keep watching us every Saturday at 1 p.m. only on TV Asia. Thank you.
Goodbye.
When writing your questions to us,